This is the fourth open session of the continuation of the hearing on 14A-020-RAC, and the time is 12:31. Chair, would you like me to do a roll call? Okay. Commissioner Heupel. Excuse me. Pardon me.
I've got about half of one. We're coming back into session on record.
Commissioner Heupel.
Here. My phone.
Commissioner Lawless.
Here.
Commissioner McClintock.
Here.
Commissioner Gray.
Here.
And Commissioner Feldmeyer is out of the room for the moment. Go ahead, Chair. We have a quorum.
Okay, we're back in session, and I'd like to give a motion to take a 15-minute break session. Just go to. Yeah, we're now going to take a 15-minute break, so Cassie can catch up. We've been running her this morning. So.
Okay, it is 12:32, and we will be on break. Ready?
Ready to come back on the record? So we'll Secretary, please take roll.
Okay, we are back on the record, and it's 12:44 p.m. And the roll call is Commissioner Heupel.
Present by phone.
Commissioner Lawless.
Present.
Commissioner McClintock.
Here.
Commissioner Gray.
Present.
Commissioner Feldmeyer.
Yep.
Thank you. We're all present.
All right, thank you. All right, and this is back to item D, the continuation of the June 28, 2016 hearing of the Terry E. Sims bill to the Arizona Racing Commission. So at this point in time, I'll open up for discussion amongst the commissioners regarding, I think we had several items that we had laid out last meeting for further discussion. So at this point in time, I'll let you guys kind of direct which way, whether we want to just discuss open right now on all of them or go item by item.
Well, Mr. Chairman, when we finished the last meeting, we finished, from my understanding, so be sure to correct me, there were items that we agreed on, and there were items that we agreed should speak further about at today's meeting. So my preference is, unless there's someone who has a strong desire to revisit the ones that we thought we agreed to, that we just begin on the items that we wanted to discuss and take them in the numerical order that they are.
I agree with that.
All right, so I think the first item is number 18.
Hey, Rory, this is Dave.
Yes.
Here. Before we get started on that, is Rudy there or Greg there?
I'm here. Greg.
Great. Can you tell us where we are in Ron's application process for his license? Had everything been turned in?
To the best of my knowledge, everything has been turned in, and he has been issued a temporary license depending on the outcome of this hearing, if I'm correct.
So everything that the department had requested for his license has been turned in?
I'm not privy to what Rudy had requested, if you're talking about the department head, since I'm not that department head.
There was one thing in the record that I showed, I read, and I just wanted to see if it was ever turned in. I just missed it. But there was a point in time where Verity met with Ron and financial state, and I took some notes on a ledger. I think I remember seeing took it off of Ron's in-house financial statement, submitted those notes, and then there was a request either a month or two later for an audited, not an audited, but maybe a, what do you call it, accountant reviewed statement, and I was wondering if that was ever provided.
I have no knowledge if that was provided or not.
Can Stacy or Marshall respond to that?
Yes, this is Stacy. This is actually not dealing with Ron's current license. And by the way, the license, as we understand it, that Ron currently has is dependent not necessarily on the outcome of this hearing. Well, it could be.
Stacy, could you repeat that?
Sure. The license that Ron currently has is dependent upon the final determination regarding Ron's past license, which is the subject of this hearing. Ron submitted a new license application in July of last year for this current time period. He is currently licensed conditionally, depending on the outcome of the license proceedings that are currently before this commission, and may have further appeals or may not. With respect to your question regarding the financial statements,
Mr. Eichel, was that question on the financial statements to them, or was it just on the license?
Yes.
Okay.
Yes, I did want to hear that.
So the financial statements, one of the allegations in the notice of denial of Ron's past license was that he didn't provide the financial statements, and we presented evidence that indeed the CPA financial statements were provided to Veride pursuant to an agreement between ADOR and Ron and Veride that they could provide them for Veride's in-person review. This happened, I believe, on April 3rd, 2013. Veride was provided the CPA-reviewed financial statements from Ron that were requested. They took copious notes and basically wrote down everything they wanted to write down and had adequate time to do so from those financial statements. And there was an email exchange between Joyce Cosby, a text exchange between Joyce Cosby and Bill Walsh on that same date saying Veride got what it needed, and I'm paraphrasing, and they will retain in notes. So that issue actually has been resolved, or at least those paragraphs in the ALJ decision have been approved by this commission in your last hearing. You went through each of the paragraphs regarding the financial statements and the provision of them, and those were approved by this commission at the last hearing. So that issue is separate from Ron's current license. Does that make sense?
Yeah, so that Ron's current license, he provided financial information that the department requested?
He provided whatever information was requested of him in connection with that application. I do not believe the department requested of him any additional financials in connection with his last license application.
Okay, all right.
So the last license application is out of this record, though. This is just regarding the...
That is correct. That is not before you today. Simply the previous license application and the ALJ decision is what's before you today. Any other questions?
I'm sorry for the interruption, Lord.
Oh, that's okay. You're here to ask questions. So you're completely satisfied with your with the answer?
Yeah, I'm gonna dig through this again.
Okay.
Make sure.
Yeah, I'm sorry. I guess I was confused by her answer. That she said it was not relevant for today. I believe it very much is relevant for today. That's one of the reasons Director Walsh denied the license, is that Ron did not provide his reviewed financial statements. He provided unreviewed, refused to provide reviewed, and I guess he says he's beyond the public records laws. ADOR is required by law to keep track and keep a record of everything they review and look at. And I guess it's Ron's position that he's special and doesn't have to put his reviewed financial statements in the record like anybody else, but it's very much still an issue.
This is Stacy again. To clarify, the issue of Ron's current license is not before this commission. The issue of whether or not Ron provided the financial statements that was part of the notice of denial is, but Ron absolutely, and there's evidence in the record, provided the CPA reviewed financial statements to Veride in April of 2013, and they reviewed them, took the notes, which are in the public record. So the issue has been resolved. So I just wanted to make certain everyone understood that what I said, and of course, the fact that the CPA reviewed financial records were provided to Veride in 2013 was confirmed in a text message between Ms. Cosby and Director Walsh.
I'm sorry.
Do you want me to argue the evidence?
I think we would like to get to...
We know you guys disagree.
No, but I just want to make sure there's not a confusion about timing. they did this, which they say was fine and resolved the issue, and then Director Walsh denied the license. That was not okay, and he wouldn't have denied the license if it was based on that. If it was okay.
Let me see if I understand this. Ron's license was denied. He appealed that to the administrative law judge, who ruled that he could have a license. Then the new director issued him a conditional license without any information other than the ALJ's decision. So Ron hasn't really applied in full for a license.
No, he has. He submitted the application in July or June of 2015, like he was supposed to. The director, I don't know if the director asked for additional information. I don't think he did. But he granted Ron a conditional license. So Ron has completely complied with whatever requirements were required of him to apply for the license of this particular time. There's no additional information that I'm aware of that the director is requiring of Ron for his current license. And that issue, frankly, is not before you in connection with this appeal.
Other than the fact that if we deny Ron's license, it will affect his current license.
If you deny Ron's license today, or essentially reverse the ALJ decision or reverse the ultimate conclusion, then we will appeal the decision to the Superior Court. But Ron remains licensed through that entire process until there is a final decision on his past license.
All right, so if we get going, I think the first item is number 18.
Okay.
If you all have it before you, need me to read it out. You got it? Is there any discussion further that we need to add to that? Yeah, 8 or 18. Which was?
Well, what's the purpose of this? To accept these as our findings?
What you're doing right now is you're doing the ALJ decision, so you can accept, reject, and modify. If you reject or modify, you have to state reasons why. If you, eventually we're going to have to, we held some in deliberation last time, but eventually we're going to have to accept the findings you want to accept and reject the ones, if any, that you want to reject.
But we have to do that now before we decide.
Well, you can do it. There's different ways that you can do this. You can discuss it, and if depending on your ultimate decision, whether or not to uphold or reverse the ALJ's decision, depends on what findings that you are going to accept or reject and what you're going to need to modify. So if you make that decision first, then we can go back and review and edit the findings of facts and conclusions of law as appropriate. If you, or you can just accept it as a whole and just say we accept findings of facts 1 through however many there are, and conclusions of law 1 through 10. It's up to you, but I would encourage you guys to start deliberating and seeing where you find the issues, and then you'll find what findings may need to be altered, if any.
Maybe we should just start having some discussion about some of our thoughts.
Yes.
Well, I know for myself, one of the things I'm kind of looking at right now is going through my head, being on the commission for a little over 4 years now, I don't know of a time where a license has been granted without a proper investigation. And earlier this morning, we've heard that there was not an investigation performed. And so I'm kind of struggling. It's like, why would we grant a license if there was no proper investigation done during that time? Yeah.
You're going past 18.
Yeah, I'm just kind of doing
overall
general. No. Which, if we know where we're going overall, it may help what determinations to make.
yes, I've got to witness an appeal by two sets of fantastic lawyers that did a great job for your clients. And I know you guys disagree on about every point. So as I was going through the record, and I know what I'm going to say is going to be controversial, but I have great respect for Bill Walsh. I think he's a man of integrity, having served with him. And I don't think, just from my personal experiences, that Bill Walsh would do anything that is that he didn't believe. I don't think he could be influenced to do something that he didn't truly believe. So, one of the things I put most credence in is his denial letter. Although you guys did a good job of documenting your differences, I didn't put as much credence in that because I knew you were zealously advocating for your client. Bill Walsh, I don't think, had a dog in this fight. And as I say, it's probably controversial to some, but I happen to think that Bill Walsh is a man of extreme integrity and could not be influenced. So, I'm leaning toward upholding Bill's denial of the license.
Well, Mr. Chairman, I also feel and have a high regard for former Director Walsh. But I got to tell you that the record does not indicate a clean set of circumstances to disallow that license. And I think that the communication between Bill and McDonald was tainted and was inappropriate. I don't think, because I feel good about Bill, that he did something in terms of those conversations maliciously, but the fact that it's on the record that he conversed and then ultimately made a decision based on what certainly appears to be a communication with McDonald is clearly inappropriate to me. And in continuing to read over and over and over the decision that the ALJ made, he said in number 10 of his I get the right terminology, of his conclusions of law, that after full review, this tribunal concludes that the preponderance of the evidence presented at the hearing established that Mr. Sims is qualified to be licensed by ADOR and that he has sufficient good repute and moral character to satisfy the statutory requirement for a license. And the preponderance, that word alone left me with the strong belief that he went into that hearing as the underdog, and he had to not only pull even, but pull way ahead in order to convince the ALJ that he needed to reverse the decision. So that's, and what I'm hearing, I kind of look at ourselves here as in the same position that the ALJ was when this comes to us, that the other side has the preponderance of the responsibility to convince us that the decision that the ALJ made was incorrect. And by all accounts, and I think you nailed it, we're listening to two very talented sides of attorneys. And whichever one we talk about, does an extremely good job of clarifying things from one to another and correcting. I don't see that Jay Sims' team here overcame that obstacle in my mind that it has to be the preponderance. So
Well,
that's where I'm at.
your point's
I'd
well
stay.
taken, Bill, but I think, unfortunately, the ALJ only got to hear one side of these two excellent teams' opinion because Mr. Manning wasn't represented in the ALJ hearing. It was the State Attorney General's office, and so it's a little bit different story. So I think the ALJ made I don't know, there are a couple of things I find hard to believe. One is the fact that he thought Mr. Sims incorrectly represented to ADOR that Bruin was still owned in whole or in part by his wife, and I don't think that was an incorrect representation. I think Bruin probably was owned by his wife until 2006. I'm not sure I buy some of the evidence like the stock certificate. I mean, I can make a stock certificate for you tomorrow if you want me to. I put any date on it I want to. So there are a few issues that I have with Mr. Sims, and I agree with Mr. Wallace. I mean, I worked with Bill Walsh for 5 years, and, you know, he wouldn't take this lightly. The ALJ got to hear testimony for 20 days, which is a long time. Director Casillas, who I have a lot of respect for too, was brand new in the job. And, I mean, I don't think he had the background to uphold or deny, to make an informed decision on whether to uphold or deny the ALJ's decision. So, you know, I think there's some things that still need to be determined.
Well, I understand that Jerry Sims' side did not have an opportunity to deal with the hearing, but that's how the process works.
Right.
You know, we're not in control of that, and they're not in control, neither is anybody else. That was set way before this question was brought to you tonight. So, we played with the cards we dealt with.
Well, that's not. It's hard to do when you're not a judge, like I'm not. This is the hardest thing I've ever had to do because I don't like to make anybody. I don't like to hurt people's feelings, and we got to make a decision here today that's one side wins and one side loses, and you know it's not something I want to do, but based on what I know, you know, I'm ready to make that decision.
But, you know, I'm like you. I was on the commission when Director Walsh was on, and actually when this came up, and I kind of remember it kept getting pushed off the agenda for several meetings. So in my mind, it wasn't just something he did willy-nilly. He was actually putting some time and effort into a decision before bringing it to the commission. And so I think there was more to the decision made that the Director Walsh made than just a phone call with something. That he was actually possibly doing some investigative work, although I've not seen in the record where it actually shows what the investigation was or how it was done. So that's also another thing for me is, in order, I believe, for this body to grant a license, we need to know that a proper investigation was done. If there was not an investigation, then there should be no license granted.
What do you think? Was there a proper investigation done?
Well, I suspect there was, but then we heard this morning that there wasn't. So but if there was one, it's not part of the record, so we can't actually see it. So we only can go with what has been presented to us, and it's part of the record, which I think right now is that there is not an investigation that was done. Is that correct? No? Is there?
Well, we have been able to pull up so we looked for the exhibits that the state put in at the lower proceeding, and I'm having
Louder.
But if you just read the ALJ's decision, it doesn't really talk about it too much. If you look at the notice of denial, it has all of the reasons why Mr. Sims was denied his license. It does not state, nor do I think it needed to state exactly the documentary evidence. But if you just give us a few minutes, we can pull up things from the record. Pretty sure it was in the state's exhibits of what was part of the investigation.
While we're waiting, I will not hear September 8th. So you can send me stuff
And right in the notice of denial, it does say that based on the department's investigation of this was signed by the director of the TP Racing permit renewal application and the license application filed by Ronald Sims does not qualify for a racing license in Arizona. So the director took both the permit renewal application for TP Racing that was pretty contemporaneous at that time, and his own application, reviewed it, and came up with the notice of denial. And so we have in the record, I believe we have what the permit application consisted of. I think we even have the application itself. So that was all part of the investigation. If you think there needed to be more, then we can see of whether or not that's in the record.
Yeah, because I thought I read somewhere that part of the reason for that denial was because of the refusal to answer all the questions on the application.
Right.
And to provide financial statements that were CPA reviewed.
Yes, in connection with the permit.
Right.
So if you have, that's not atypical, right? I mean, if you want to get a license from an agency, you don't provide all of the information. Most agencies have statutes that allow you to, I mean, you could subpoena and do all those things of an applicant if you have the statute of authority to do that, but ultimately, you can also decide as an agency to deny a license on that basis because they are not disclosing everything or the application is not complete.
Chair, I don't want to argue, but I just want to clarify our position as to the lack of investigation, just so that you understand. Our position is that there was no investigation of the license application, and as such, the notice of denial of the license can't stand. Not that there should be no license granted, but because there was no investigation, the license application should not have been denied. So ultimately, our position is that you default to the ALJ decision, not to the notice of denial. Thank you.
Well, and that seems to have things back-assward, or whatever that term is. The default should be to Director Walsh's studied, deliberate decision where he lists the things that Ron failed to do or list the misrepresentations Ron made. And based on that, he said, how can I license a man who's not provided a reviewed financial statement? He let Verity peek at it, but wouldn't put it in the files, unlike any other applicant, and refused to answer questions under oath during the permit interview, under oath. And again, I say to you, how in the world can a body like you or any other gaming regulator give somebody a license in a gaming industry that refuses to answer your questions? I didn't even know why we're here. I mean, if I were, and again, I wouldn't presume to take a commission share, but if I were on the commission and you had somebody that said, I'm not going to answer your questions, that would be it. Forget the lies, forget the failures to disclose. He didn't participate in the process like every other human being must to get a license.
So,
Wait. I have to respond to this.
I want to say, if you look at the department's first amendment list of exhibits, you get a pretty good idea of what was proposed at OWA, and that includes the notice of denial, the mentioned notice of appeal, and then if you go down, they have the financial investigation report of TP Racing, prepared by Verity Consulting in November of 2013. They have, and I'm just going to sort of highlight what was most recent at that time. There's a whole bunch of things from 2003, 2006, 2009, those investigations. And there was the interview of Ronson by the Department of Racing dated September 11th of 2013. There is all of the corporate annual reports. There is an under advisement ruling by Judge Reyes dated May 14th of 2013. There is a letter from Director Walsh to Jerry Sims dated March 8th, 2013. And those were in the first. They filed supplemental list of exhibits, but those are the first set of exhibits that the state proposed. So there's at least some indication, and we could go through the actual transcripts of the hearing and go through and see what kind of investigation was done. But we'll take a second look at it, but it might be in there.
Mr. Manning chose to argue, so now I'm compelled to respond. There were allegations in the notice of denial that Ron didn't provide the financials and didn't answer questions. We disproved those allegations at the ALJ hearing. We proved to the ALJ that he provided the requested financials, did not fail to cooperate, and that he did not refuse to answer any questions. That is all of the evidence that is in the record. Yes, ADOR put in their evidence to say he didn't answer and he didn't provide. We then countered that with our burden of proof and showed that he did provide the financials and he did answer the questions, or if there were questions that he didn't answer, it was because they were based upon privileged information or they were withdrawn, what have you. That is all in the record. Our point is that there was no investigation of Ron's license. There may have been an investigation of the permit, but there was no investigation of Ron's license, no two-way street, and the first time we were ever able to do that was before the ALJ. So the ALJ hearing was essentially the investigation of Ron's licensure and whether he was fit for licensure.
It's going to be we need to have some discussion up there.
This is just directly apropos of what you just heard. With respect to she said that he answered questions. I'm going to show you just two slides. Could you put up 38 or 39? I'm sorry. This is from his interview. Put up the other one too, please. ADOR says the overall question is, in your opinion or belief, that Bruin was only a landlord and no ownership interest in TPR, as you testified. I don't think I want to answer that question. Next. Then he's asked about the conflicting testimony, the perjury, the lies. He said, why is there conflicting testimony about the ownership of Bruin Courier deposition and other lawsuit documentation compared to what is submitted to the Department of Racing? It's our position that Mr. Sims is not going to testify about testimony that he's given or statements that he's made. That's the issue of the litigation. My word. You're not going to answer questions about, you said one thing in 2000, one thing in 2003, something else in 2011, and you're under oath. And Ador, by the way, Ador told Ron they were going to ask him about this and told him it was relevant. Put up the next slide, please. Ador says if there are inaccuracies or material issues in Ron's prior testimony or disclosures to Ador prior to the date that have arisen during our investigation, it is relevant. I'm sorry, let's, for time's sake, go 40. Not this one. That's Ador telling Ron these questions are going to be relevant. Put up 40, please. I just don't want to take any more of your time. 40. Ador, what is your testimony today as far as Ador? What is your testimony today as far as Ador? Maybe confirming is not the right word, but acknowledging you could transfer your land to TPR in exchange for the cancellation of the note. Ron won't answer, but his lawyer jumps in, okay, it's the same thing. It's an issue in the litigation, so I'm not going to have him testify about issues in litigation. There's no privilege not to testify about issues if they're in litigation. He's been testifying in litigation in a public record for years, but he won't tell Ador. He won't try to confirm that or fix that with Ador, explain it. Again, my word, what are you all thinking here? An applicant cannot do this for a gaming license and stiff-arm the regulator and say, I'm not going to explain my conflicting under oath testimony. I'm not going to answer questions with respect to this oral side deal. That's the oral side deal. He won't answer questions about it.
I'm tired. I'm really tired of this. I really am. Jeff Walsh testified at the ALJ proceedings that he had a conversation with Director Walsh before this interview and said if there are any questions about the litigation, I am going to answer them. I, Jeff Walsh. And Mr. Walsh, Director Walsh, did not object to that. And in fact, after this interview, Jeff Walsh sent a letter to Ador answering these questions. This is all in the record. This is misrepresentation as to what happened with respect to this interview. Not only that, this interview took place before Ron applied for a license. It wasn't part of his license application. It was part of the permit renewal process. And at this time, Ron Sims had no idea that the department had any concern about any of this issue. He had no idea why these questions were even being asked of him. There was nothing at issue for these questions to be asked. And he was told by his lawyer, and his lawyer was told by Director Walsh, that that the lawyer could answer the questions. So these little snippets that he's showing you does not explain the full story. And that's what we told the ALJ when we had the 20 days of trial. So I'm certain Mr. Manning will get up here again and try to show you more slides.
We're done.
But I would suggest if you want to know the full record, read the record of the ALJ proceedings regarding this issue. Thank you.
Another oral side deal.
We're done. Mr. Heupel, do you have a question?
Well, are we still on 18? I know
it's the general overall case.
We're on 5,000.
You've been taking a nap in the cool weather?
Yeah, 18.
I am still bothered by the findings of fact number 18. We expect someone applying for a racing license to be totally honest, answer questions, provide information, comply with everything that the ADR folks' application process consists of. And it's just beyond me when and again, I don't know, again, I don't know all the players. I've never met Ron. I've never met Director Walsh. But I am the new guy in the group. But for the life of me, I cannot understand how Ron continue to represent that Vicki owned the Bruin entity through the whole process when he knew he didn't want to provide financial information. He knew he didn't want to get his wife involved, in this whole process, potential licensing, the safety concerns that he mentioned. Common sense would just tell you that at that point he would say, well, wait a second. No, she doesn't own Bruin, I own Bruin. And here's the stock certificate to prove it. But that never happened for 6 years. So I have a real problem with that finding of fact, because I'm not, I don't want to call anybody a liar, but I just can't believe that whole event went on when he knew that he didn't want to get his wife involved in a lot of these things. So I'm stuck on 18. I don't have to go any further.
Okay, but Dave, we're going over your thoughts on the entire proceedings. We tabled 18 until we got a kind of a clearer idea of how each commissioner felt about the overall case.
Well, I think from that,
I can.
Well, I can tell you when there's, and to me that's material. The oral side agreement with the notes and those things, and the ownership. That's enough. I'm in a position where I'm ready to make a motion to reverse the director's decision to grant Ron a license.
So you would vote to overturn Bill's denial of the appeal, or you would vote to uphold Bill's denial of the appeal? Bill Walsh.
no.
Well, we're voting on
The ALJ.
The director's decision. Is that correct?
Oh, Director Castillo, not Director Walsh.
Yeah.
No. Director Castillo, Rudy.
Yeah, Rudy.
Or non-response, which was a affirmative decision.
Right.
Did that answer your question?
Yes.
Yes.
Okay.
Well, let me just say before there's a motion, in reviewing again the conclusions of the law that the ALJ provided, said on number 4, that Mr. Sims established that he did not make a knowingly false statement of material fact to ADOR as prohibited by him, and it quotes the statute. In 5, it says Mr. Sims established he had not failed to meet a monetary obligation in connection with any racing meeting held in the state. 6, Mr. Sims established he had not entered into a contract or contracts that would not further the interest of racing or be in public interest as prohibited by ARS.
Read number 4 again. I wasn't paying attention.
Mr. Sims established that he did not make a knowingly false statement of material fact to ADOR as prohibited by the statute.
I think that's what Mr. Heifel was referring to, and I referred to earlier, that how could he not knowingly know who owned the Bruin Corporation? 2003, 2005, 2001.
Well,
And I think that's the heart of the issue, is we're here to determine whether we agree with the ALJ's finding of facts or we don't.
Right.
I don't think just because it says it there that it makes it so.
Well, for me, one of the things that the ALJ, I believe, was that even though I think it could find no evidence of the said meeting, because Ron made an attempt to find paperwork that it must have happened. And in the real world, I deal with SOX audits all the time, and I've had auditors ask me for documentation, and I'll spend hours looking for it, and they're looking right over me. And when I can't find it, they nail me. They don't say, "Well, you made an attempt. It must have been there." And this is the first time I've ever heard of such a decision that, "Oh, he looked, it must be there." To me, that blows my mind away.
Yeah. Well, I'll just tell you my experiences as a reasonably successful small business guy who deals in buying and selling and trading properties for 40 years. I can't remember what happened from one deal to the next. Except that I know I made a profit. And I never can tell you which ones I lose on. But if you ask me the details of how I got there, I really can't remember. I'll confuse one with the other every single time.
But Bill, I don't think it would take you 6 years to figure out that you made a mistake.
You might be right, but I'm not carrying the kind of load that I heard they're carrying either. And as I understand it, and read it a couple times, it was a moot point after 2003 anyway. 12 years later, this becomes an issue. 12 years after the fact.
I don't think the issue is actually the ownership so much as it seems to have a tendency to say whatever's expedient at the time to get the result that he's trying to achieve. That's at least that's the inference.
Well, like the rest of you, I've never met him either.
I don't know. I'm not sure.
I didn't spend 20 days, although it feels like it, in hearings over this. And I just tell you, I don't see this thing being flipped. I don't see the preponderance of all this evidence flipping with a guy who spent 20 days and all that testimony came up with. And not only that, I don't see what harm it's going to be to give the guy a license. I'm still struggling with why Jerry Sims is aggrieved. He's a 10% owner, or was, and I know that's in dispute. It's not part of our deal.
Jerry's the majority owner, is he not?
No,
Right.
Ron was
Ron is a
34%.
10. It was listed.
No.
It was over 10. That's right. Excuse me. He needs a license for over 10. But he still doesn't control the track.
No.
The majority owner is Jerry. That's his role. That's his job. That's never been in dispute. And that's not going to change. And it shouldn't change.
Yeah, I think that's obviously what I consider. Yeah.
We're trying to decide if the ALJ erred. I think Ron, they're saying Ron should be able to have a license.
Mr. Chairman, may I ask a question? Okay, one question? Sure. Just one. It's not just one.
Is whether or not any of you, in passing on your ultimate decision, are influenced in any way by your social personal relationships with Jerry Sims, or the fact that you've never met Ron Sims. Do any of you have any real or unintended bias here because you're passing judgment on a complaint, Rod?
Can somebody speak up? I can't hear who's talking.
Do any of you, it's Marshall Grossman, do any of you have any actual or potential favoritism here toward Jerry because he's a social, eating, drinking, partying friend of yours?
Eating.
I don't think it's necessary.
I don't mind the answer.
If you want to, but you don't.
Yeah. Well, although eating, Jerry doesn't drink, so he's not a drinker. But no, I don't think I do, Marshall, and that's why I gave the reason for why I voted the way I did, because you convinced me. And when I first got on this commission, I knew Jerry Sims, and Jerry can tell you that I said we're probably going to disagree a lot, but we'll agree to be friends. And I would have no compunction if it weren't for my respect for Director Walsh. That's what tipped it for me. I was on the fence. I was truly on the fence, and so I had to dig down in my experiences because I didn't know which way to vote. And it's not because of Jerry, it's more because of Director Walsh.
Would it have made any difference in your opinion if you knew that Director Walsh refused twice to testify during the ALJ proceedings?
This is an attempt.
That's not part of it.
I just wanted to answer your one question about my bias to Jerry. I don't want to get in a back and forth about the facts.
This is just an attempt to intimidate the commissioners. I think you should continue with your deliberations, move, vote, and let's move on with this.
And for me, since they're brothers, I picture a Jerry lookalike sitting right behind you. So, since I've never met Ron, know what he looks like, I just picture that he looks a lot like Jerry. So.
But he doesn't have Jerry's record.
I don't. Unless
Mr. Heupel?
Yeah.
Do you have anything? Or?
Other than, I guess, for Camilla, what is the process at this point? Is it a motion? Is it, do we write something up, addressing this? You give us some guidance here. Or do we need to go to the executive session?
We could go into executive session. Because your question, I think, is a little bit more complicated than just a quick answer.
I move that we go into executive session.
second.
Who seconded that? I'm sorry. Give it to Tom. Okay. Okay. Art, you want to call for a roll?
Roll call, please.
Okay, Commissioner Heupel?
What's that?
We're doing a roll call for the executive session motion.
Oh, yes.
Commissioner Lawless?
Yes.
Commissioner McClintock?
Yes.
Commissioner Garay?
Yes.
Commissioner Feldmeyer? Okay, we are recessing the open session at 1:37 to go into executive session. This will be the fifth open session of the continued hearing on 14A-020-RAC, taking place at 1110 West Washington, Suite 250, Phoenix, Arizona 85007. Okay. All right, we are going back on the record, and it's 2:02. Would you like me to do a roll call, sir?
Yes, please.
Commissioner Heupel?
Present by phone.
Commissioner Lawless?
Here.
Commissioner McClintock?
Here.
Commissioner Garay?
Here.
Commissioner Feldmeyer?
Yes.
Thank you. We're ready to go, sir.
All right. Welcome back. And I think what I'd like to do is start going through the items that the last meeting we had set aside that we needed to discuss and go through. So with that, I guess I'm appointed to read them. Or maybe I should appoint one of you to read them. Oh, you want to read them?
You want?
Yeah, I'll have you do it.
These are the items that warranted further review. Item 18, Mr. Sims has owned Bruin since sometime in June 2000. Prior to June 2000, Bruin was owned by Mr. Sims' wife or members of her family. There was no dispute that from June 2000 through 2016, Mr. Sims incorrectly represented to ADOR that Bruin was still owned in whole or in part by his wife. That was the issue we talked about earlier, that I believe he correctly identified the fact that Bruin was owned by his wife until 2016. So
2006?
6, I mean, yes. So, I guess the idea is to get everybody else's opinion on that, if everybody has one.
Well, my opinion is during that time he did misrepresent to ADOR who was the owner of, if he was the owner of Bruin, then he misrepresented that it was his wife. So there was a misrepresentation to the Department of Racing as to who was the owner of Bruin.
Anyone else?
Well, restate it, but I've stated my position, and that is, Ron's indicated that he had other people filling out his paperwork and relied on other people, and somehow overlooked this, but the fact of the matter is that if Ron was so concerned about his wife, and throughout the testimony was concerned about his wife's safety, clearly would have indicated before 2006 that he owned Bruin and not her. So my position hasn't changed.
Well, Mr. Chairman, I disagree. I don't think that it's as relevant as it appears to be. I think that the explanation that's been provided to us by counsel explains that. And I think the hearing officer, the judge, understood that and pointed that out in his conclusions of law. So, respectfully, I disagree.
We move on to item 19.
That would help us out a lot.
Have a feeling of
I have a way better feeling than I did at the beginning of today. For number 18, yeah. So it will roughly say. Okay. So it will roughly say that. I'm just reading it in the context of the other findings of fact. So, I mean, the findings of fact would read something like from June 2000 through 2006, Vicki Sims owned Bruin Corporation. I mean, that's basically what you guys are saying, and that and so because we're changing it, we would cite to the record of where it is that.
Okay. Item 19, 2003 ADOR considered whether Bruin, as then owner of land containing part of the racetrack oval, should be required to have a racing license, even though ADOR at the time understood that Bruin was owned by a non-licensee. Mr. Sims' wife, and did not require that Bruin or Mr. Sims' wife be licensed. The issue of licensing Bruin or Mr. Sims' wife became moot in 2003 when ADR requested that Bruin agreed to and did transfer its land essential to racing, including the part of the racetrack oval, to TP in exchange for land not essential to TP, nearby trailer park. Bruin did so through a 1031 exchange. Since the time when the land that was essential to racing was transferred to Turf Paradise in 2003, Bruin has not owned any land essential to Turf Paradise Racing, and there was no further concern over the ownership of Bruin until the denial of Mr. Sims' application. And I agree with that. I don't seem to have a problem with that.
I'm trying to figure out why we pulled that one.
Based on the record, that's all true.
Okay. Item 21, Mr. Sims identified himself as the owner of Bruin since at least 2006, and his 2006, 2009, and 2012 ADR interviews in connection with the permitting of Turf Paradise Racing, even after having been informed of Mr. Sims' prior incorrect attribution of Bruin ownership to his wife and the corrections made in 2006 and thereafter. ADOR raised no concern about the ownership of Bruin until the denial of Mr. Sims' racing license. And I agree with that too. I don't have a problem with that. Anybody?
I'm not sure why we pulled it.
Well, I think there's, if I may, I think there's some issues about whether or not you might have pulled it because we're reading this as quickly as we can, but whether or not the corporation was material to the issuance of the license. I think you probably agree with, or most of you agree with most of the findings, that there are things in there that you may disagree with, given your overall impression. So I would encourage you to take it sentence by sentence and look at it.
This particular item refers to at least since 2006. We don't disagree that Mr. Sims became the owner of Bruin in 2006. It's the period prior to that when he stated that he mistakenly attributed to his wife when it was really his.
But do you agree that ADOR raised no concern about the ownership of Bruin until the denial of Mr. Simpson's racing license?
I couldn't find any. There's nothing in the record that shows.
Well, I thought there was some concerns, and that's why there was a land swap.
That was in 2003. I mean, if you guys feel differently, please feel free.
Excuse me, I think your concern from last time was the prior incorrect attribution language.
Right, and I think we pretty much cleared that up with item 18.
I think so, but this is inconsistent with 18 as you have revised it. Right. Because of the prior incorrect attribution, it was prior correct attribution that he owned.
And there's several sentences in each finding, so I'm still going through finding number 19 to make sure that there isn't anything in there that would contradict 18. think in 19, if you could discuss the very last sentence, and there was no further concerns with the ownership of Bruin until the denial of Mr. Simmons' license application. If you still want that in there, is there anything else? Well, yeah, the issue and whether the issue of licensing Bruin or Mr. Simpson's wife became moot in 03, if that's also what is something that you guys agree with.
I don't. Because if the finding is that she owned it until 06, it would have been of concern.
Excuse me, Commissioners, may I make a suggestion? Wouldn't it be easier for all of us if a motion was made to either accept or reject the ALJ decision, and then based on that decision, based on whatever vote we take, each side submitted to Camilla proposed findings of fact that address the issues that you've identified in this collection of 15.
I like that a lot.
But, may I respond? Where this thing got off the rails in the first place is when outside lawyers got involved in drafting the notice of denial. And this is a requested remedy that will create the same mischief with respect to whatever decision you're making on individual findings.
I can't hear. Could somebody speak up?
Yes, this is Marshall Grossman, and I'm saying that where this entire matter went off the tracks at the beginning was when outside lawyers got involved in trying to do the work of Director Walsh and fashioning things to their own advantage. You've now made it clear that this is in your hands. You're deliberating, you're deciding. You should not delegate to us the responsibility of drafting findings. You have a complete set of findings and conclusions that you can either agree with, disagree with, or modify.
Excuse me, just make sure that we're clear. Marshall Grossman submitted findings of fact and conclusions of law to the ALJ, so did the state. Both sides did that. We didn't. We weren't parties. But that's the way these things are done before judges and commissions and bodies that have to make findings of fact and conclusions of law. Once you make a decision, both sides then can give you a very discreet, very short set of findings of fact and conclusions of law that follow what the ALJ did and what Director Walsh did in his notice of denial. It will save everybody a lot of time and effort rather than going through each one of these and trying to redraft. Sitting here today, we'll be here well past 5 if we try to do that.
I agree. And I think it's important that the lawyers have input. We're not qualified to do this.
Well, but we do have our own counsel, and
I mean, she is with them.
But to me, it sounds like a great idea, but we're going to get inundated with mounds of paperwork, and we're going to be having to talk to our counsel even more because, we're just going to be overwhelmed with more paperwork, and we're already overwhelmed with paperwork.
Well, no,
you're absolutely right about that, because the way it happens at the trial court level, and it is true that both sides committed findings of fact and conclusions of law. By the way, before they knew the decision of the ALJ, so we submitted ours assuming we would win, and they submitted theirs assuming they would win. And then the ALJ actually didn't adopt any of them. But what happened was there was about 30, 40 pages of documents that went in from one side, and then there was 30 or 40 pages of objections on the other side, and then you're going to have to review all of that, and then you're going to have to talk to your counsel, and then we're going to be coming back here in a month. And I think that it makes the most sense. You actually don't have that many paragraphs at issue currently in here. I think there's 5 factual paragraphs total. I'm happy to sit here and get this done today so we can get a decision and be done with this.
Both sides can do this.
Yeah, I'd like to continue on now because, I I think we'd like to get this over with today, and if we can. So the more you guys talk, the less we get to do this, and we are into the discussion now of these. So get back.
Yeah, we're going to look at this, and we'll give you the final findings. But I think we have a pretty good idea of what you want Chris and I to do.
By the way, you skipped 19. I'm sorry to interrupt, but you went past 19.
She's talking about.
Yeah, we're not doing 19 right now.
All right.
All right, so can we move on to 20?
And may I clarify?
Oh, I mean 20.
May I clarify? We outside lawyers are not to get involved in your internal process.
Mm-hmm.
Is that correct? Not give you more documents?
Correct.
No.
Save a tree.
Yeah.
So we can move to 21 now. Okay. Oh, did we already? Yeah, that's right. We already read it. So let's reread it again.
Okay, Mr. Sims identified himself as the owner of Bruin since at least 2006. In his 2006 and 2009 and 2012 ADR interviews in connection with the permitting of TV racing.
Anybody have a problem with that sentence? I don't.
No, I think that's all true.
Even after having been informed of Mr. Sims' prior incorrect attribution of Bruin ownership to his wife and the corrections made in 2006 and thereafter, ADOR raised no concern about the ownership of Bruin until the denial of Mr. Sims' racing license.
Yeah.
I think I have a good idea of what you wanted.
Okay, good.
All right, moving on to number 22. Mr. Sims' testimony regarding his incorrect representation from 2000 through 2006 that his wife was the owner of Bruin was a product of mistake or error by himself and third parties who prepared forms for filing with government agencies is found to be credible. Now that I have a problem with. I think Mr. Sims is a lot smarter than I am, and I would have had a problem with that. So I can't imagine, even though he had 70 entities, that he shouldn't have known what the tax returns and the corporate commission report said about the ownership of Bruin.
And that's where I respectfully disagree. I mean, it's based on my experience, my personal experiences. It's happened to me before, and if I live long enough, it will happen again. There's no doubt.
You're going to live long enough.
If I live long enough, you're right.
And the final sentence is Mr. Sims' incorrect representation from 2003-2006 that his wife was the owner of Bruin is not found to be a knowingly false statement of material fact. And I disagree with that for the same reason. I mean, I think it is a knowingly false statement. I think he knew who owned Bruin. I don't think we've seen it.
I'd reply the same.
All right, item 27. Mr. Sims' testimony regarding the conversation with ADOR representatives in 2000 is found to be credible. Now, yeah, I mean, that's the one where he had the conversation with two accountant types from ADOR that told him to write the promissory note. And that's hard to believe too, since there's no record of it, nothing in writing, nothing to prove that. I mean, somebody, I can't imagine I wouldn't remember if somebody told me to do that. Who told me to do it?
Who was, refresh my memory, on the record, who was there to say that that wasn't accurate? And what did they say?
Nobody. I mean, because, you know, it's so ambiguous that, yeah, you can't.
But he didn't know who the two representatives were.
No.
Usually you would document something like that, but it was not documented.
Well, that's something that happened 15 years before?
Mm-hmm. Or 13, or depending on what this application filed.
See, I think there was no evidence of it, but the law judge found it credible just because he said it happened. But there's no evidence that it did happen, other than Ron's testimony that it happened.
Then he believes his testimony.
Right.
Am I right? I mean,
yeah. I mean, he believed it. I can't imagine that's the way the Department of Racing did business in 2000 or would do it today. I hope not.
well, I don't know that that's necessarily how they did business, understanding how it was going to result 15 years later. But people have conversations all the time about, okay, you do this and I'll do that.
Those
If it works, then nothing happens.
They should be in the file, the Turk Paradise file. That Jerry owes $14 million, Ron owes $4.6 million. And they can be paid at a later date by throwing their land. I don't know. I think there'd be something right. Consequently, ADOR did have notice of the issue that Mr. Sims believed the makers of the promissory notes could elect to pay their respective promissory notes with cash or by the transfer of their respective entities' land to TP in 2000. So, once again, if you believe, I mean, this only makes sense if you believe that he was told by some unknown accountant type to write the note, then sure. But because I don't believe the first sentence of it means.
You can't believe the second.
Yeah. And the last sentence is the determination as to whether Mr. Sims' promissory note can actually be paid off by utilizing the Bruin land instead of cash will be decided by the Superior Court in the ongoing civil litigation.
I agree with that.
Yeah, I mean, we know nothing about that, so I don't know who's going to decide that, but it sounds like the Superior Court will.
I will say that in the minutes from the last meeting, there was an indication, although it was not in my notes or Chris's notes, that you guys also held on to finding of fact number 12. If we could just go back there before we reach the final one, I greatly appreciate it. So 12 reads, and it's and 12 reads, Mr. Sims is a passive partner with respect to TP.
I thought we got that it was the ownership percentage already on that.
Okay.
Well,
I have written down 32%.
Yeah, like I said, it was not in our notes to hold. I don't really recall the parties talking about it, but it was in the minutes from. It's posted online as part of the minutes from the last agenda as one of the findings of fact. So I just wanted to
It's correct. I have it circled, but I have passive underlined, and I think that was what was questioned and when it was determined.
Yeah, what is the definition of passive?
Well, the way I understand it is,
Less than
I'm not
majority.
sure this is in the ALJ record, but that he was passive in the day-to-day operation of Turf Paradise, but active in any major financial decisions made regarding Turf Paradise, because he and Jerry owned the managing partnership of Turf Paradise 50-50, which was one share each of Turf Paradise stock.
Does that make him a passive partner?
Sort of.
It's up to you if you guys want to.
I don't think it's relevant.
Yeah,
Okay.
I just delete them.
I think we had answered our question.
We could just leave it in. How about that?
Okay.
I just wanted to make sure that.
You make the call.
Oh, I can't. Okay.
All right, so we're down to 52. In early November 2013, Jay Sims' attorney contacted former director W. Walsh directly and encouraged W. Walsh to revoke Mr. Sims' racing license. W. Walsh had a draft notice of hearing and revocation of Mr. Sims' individual racing license on November 15, 2013. Well,
That's the voting.
I don't know. I mean, I think, in my opinion, Mr. Walsh wrote his letter of denial himself, and then unfortunately submitted that to Mel McDonald, let him read it. It probably cost Bill Walsh his job, which is kind of sad to me because he did a great job as the director of the Department of Racing. But I think the decision to deny was already made by Mr. Walsh. I don't think Mr. McDonald had anything to do with it other than clean up the language.
But that was the problem. And he didn't have any business, in my view, in having any part of a conversation related to that decision.
Well, I would agree with that.
So it tainted this whole thing.
I don't know if I'd go that far, but it did cost Bill Walsh his job.
Well, the question is that 62 materially correct? And I think it is.
Well, I don't know about the prior contact. I think I don't remember seeing anywhere where there was testimony that there was a prior contract. I thought it happened after Bill drafted it.
Well, it says, let's see.
Was drafted and then reviewed by McDonald. Suggestions made.
Yeah, I think, I just don't know about the first sentence. I think the second sentence is right. And I think we could put in there that subsequently it was distributed and modified to Mr. McDonald.
Satisfaction.
I think that's finding of fact number 53, which is before the draft notice to be finalized. Former director W. Walsh discovered that Mr. Sims' individual racing license had expired, and then he notified Jay Sims, the attorney for the company, that Mr. Sims did not hold a current racing license, and that, then it says former director W. Walsh did not disclose that he had previously prepared a draft notice of hearing revocation of Mr. Sims' expired racing license. So this is not the notice of denial. This is the draft hearing and revocation. So he had, what this is saying, presumably, is that he had made a decision subsequent to subsequent to an investigation that he was going to, at the very least, start a proceeding to revoke the license, but then he realized there was no license to revoke. So I don't know if you want to change anything. This is not the notice of denial. This is actually something that never got issued. It's a notice of hearing for revocation, which is different. That it would have assumed that Mr. Sims had a license, but then they found out that he didn't, and then the notice of denial came out. So you want me to leave?
No, I think you can
I think that's the end of it.
All right. Well, let me see if I have questions for you. Are there any conclusions of law that you want to remain from 3 to 10? So the first one, I mean, there are some that you might consider that you might want to reconsider, or else I can just I mean, I could put them in a draft form. I mean, I could ask you questions about it right now.
Yeah, I've got a question about number 4.
Okay.
The question or the statement is, Mr. Sims established that he did not make a knowingly false statement of material fact to ADOR prohibited by ARS 5-10883. I'm not sure he established that.
Got that one.
That's the only one I had circled.
What about 5? The monetary obligation.
Yeah, I mean, as far as I know, he didn't fail to make any money. Well, unless you consider the called note obligation, that's going to be decided by the Superior Court. And he said he contributed his land, and Jerry's side says that that's not good enough.
How about 6?
Bill, can we jump back to 3?
Yes.
Sorry, establish that he did not violate the racing law of the state of Arizona when he was previously licensed.
Trouble with that. He made false statements on
Yeah, the misrepresentation on the ownership was in previous licenses. So I do have a problem with that.
Okay.
Well, for my part, my minority role in this, I would attach to that to my satisfaction that was explained. I'll let you figure out a way to draft that into one sentence.
You want me to draft dissenting findings of fact?
Yes. I know my minority rights.
So 6.
Contract or contracts?
I don't think there was anything it's accurate the way it is.
I know it's due at 7, but let me know what if there's anything.
Okay.
I mean, I assume 8's okay.
It's just more.
I know it's due at 10. So what I will do is I'll draft the new findings of tax institutions law, cite the record, and then I think that's your next meeting in September 8th.
Yes.
I think it's the 8th.
2 weeks, 8.
Okay, I might have a conflict.
Well, is that going to be one where we need to have both parties present? No.
Well, I mean, no, of course. I mean,
It's
they can
an open
always
meeting.
show
They
up.
can come.
I would.
And you can have this done in 2 weeks?
Yeah, I
You
can
don't
have.
a
Yeah,
conflict?
I can. My conflict would be that I would be in Tucson at a hearing, but I'll send Chris over, and but I might not have to go down that day, so it's. But I will try to do this as quickly as I can, and then I'll give it to the parties so that they can have it.
And we'll have agreed on giving you any changes we have prior to the meetings, so you can just have final ones to vote on, right?
Right. The point would be for me to have, based on what I heard today, and I'll review the record and the recording of today's discussion, and I'll review the actual record and make sure that everything is supported by the record, so that when you receive it with the materials, that you would just be able to accept those.
Okay.
And if there needs to be any changes, we'll be prepared to make them
At the meeting.
at the meeting, because I'm hoping that if it is any changes, they would be very minor.
Right.
Is how much time before our meeting will you get this to us, Mel? It really would be nice for us to be able to have those with all these documents that I'm looking at, and be able to make sure that
Right.
that's what I would like to say.
I have
I don't need a week, but it would be nice if it was a couple of days.
I will try my very best to have them done the Friday before Labor Day.
I think it would expedite the process in our meeting.
Yes.
To be clear, even though you're providing them to us, we are not to comment or submit anything to the commission, no objections, nothing.
Right.
Will there be any argument on September 8th?
We don't. I mean, this is the opportunity for them to let me know what they were thinking, so I can actually draft it, because we had not had deliberations before. So I want to take this opportunity for them to tell me everything that concerns them, so I can draft it. So yes, it won't be necessary to comment, to argue. It will be done, and then you'll have a final order, and once it's signed by the chair, then that's when the clock starts ticking.
But we're not permitted committed to submit anything in writing when you provide this to us, correct?
That's not my call. That's on them.
I've got a stack of paperwork that, it's like, I'm afraid to just, when this is over, what do I do with it? I'm afraid there's something in there that shouldn't be out in the general public, and I don't want more of this stuff.
I mean, if there's something you do want to submit, please let us know.
No more paperwork.
I mean, but if there's something you do want to submit, please let us know. Please let us know now.
And what is this? Did I hear September 8th? Is something planned for that day?
They have a regularly scheduled commission meeting.
And that's the Thursday after holiday.
Yes, that's the Thursday.
And so that you all know, I'm not here. I'm gone. I'm leaving Saturday. I went back until the 14th.
Telephonically.
No, fine. But I will pick up emails, so I will be able to. I hope I will be able to review, which would be helpful for me to have it as many days as possible beforehand also. Because although they say I got Wi-Fi, I don't know the quality of it.
Yeah.
When are you leaving?
Saturday.
This Saturday?
Yeah.
Lucky dog.
Think about that.
Just so I understand, I'm not as familiar. Mr. Feldmeyer won't be here.
Right.
Can he still vote?
He can't. Because he's not going to be here. And so
Should we put this at the next meeting in October then, so that Mr. Feldmeyer and everyone who's sat through all of this is allowed to vote?
I think.
Yeah, we can't meet before he's leaving this Saturday.
Right, no, but I mean to October. I mean, I would prefer it to be done today, but I see that that's not going to happen. So I want every commissioner to have the ability to vote on the decision.
Can we call a special meeting?
We're gonna vote on the decision today. It's the findings of facts and conclusions of law that we're gonna review and approve at the September 8th.
Well, no, we're going to vote on everything at one point. Because otherwise you vote on the decision and then you vote. It would just look better if we do it all at once. Yeah, we were prepared to do everything today. Vote on the findings of facts, conclusions of law. But I don't think we're going to get that done.
Oh, I misunderstood. I thought we were going to vote on the denial or approval of the license today, and then do the finding after. I don't know.
I think it's better to do it all at once.
Well, I agree. I agree with Stacy. Bill should be here.
Yeah.
The next commission meeting would be on the 13th of October. If you want to have a special meeting, then it's going to be subject to the availability of the parties as well as this conference room.
We could have it telephonic.
Yeah.
Okay. I don't know how to get everybody in telephonically.
Yeah.
That's a lot of people to conference.
Well, we can set up a conference line.
Right.
Well, I mean, they can appear telephonically.
Okay, but again, I have to have a location with people coming in then.
I know there's conference lines that hold multiple people, and then you can have control of muting everyone.
Right.
But and then maybe we might have to use one of those that also we can do it on your computer so it can see if somebody's raised their hand and asking a question or has a comment to make.
I'll check with my IT.
So we're locked in for a regular
Thursday.
meeting on the 8th.
Mm-hmm.
Is that right?
Thanks.
Yes,
It's going to happen.
September 8th.
Tennessee.
I don't.
Camilla?
Yes?
And this may be asking it too soon, but how long do we need to keep all these records? And when we do get rid of them, do we have to destroy them? Do they have to be shredded, or what's protocol?
So the state has a copy of the record, or the department.
Yeah, the department has a copy of everything, and they're obligated to keep everything.
Yeah, no, these are the ones that have been sent to me. I've got stacks all over, spread out right now, all the binders, everything of record. How long after we make a decision do we need to keep those?
Let me check and get back to you on that.
Okay. And once we get that also, do they have to be shredded?
Time as well.
On the 13th.
I believe so, in Delaware.
I mean, at this point, they're all public record, but I would still, even though they're all public record, there's still a lot of information in them. I recommend shredding it.
Okay.
I think we're going to have to do for the next meeting, we're going to have to do a special meeting somehow. I know you're gone on the 13th. I'm out of town. I'm in Delaware on the 13th. Well, I would be able to call in and I could be here.
In October?
In October, yeah.
Okay, so we'll figure out a way to meet in mid to late September. I'm scheduled to be in hearing from the 8th of September through the 23rd. But I can probably get you guys in once Commissioner Feldmeyer comes back. And then, when do you come back?
Cassie, could we make
You're
that
maybe
the
coming
October
back.
meeting too? Since he's not going to be here, I'm not going to be here.
I'm sorry, what was your question?
Could we make that late September meeting,
The October meeting?
the October meeting, and then meet again?
That's where I was going with it. But
Okay,
again, I
good.
need to find out the availability of the room. We could just
So you guys might
move it up and move it out.
Yeah, today and then late September, but then we will not meet in October.
Okay. Are you still meeting September 8th?
Yes.
Yeah.
Okay.
Because the season gets ready to start.
Okay.
Somebody summarize this.
Yeah.
I confused you, Marshall.
I think
Then let's go back to the oral argument.
Yeah.
I think there's going to be a special session set sometime in late September. I presume Cassie will do, as she graciously always does, provide us with dates or ask us for a date of unavailability.
Yes.
And then we will hopefully find a room where all or some of us can appear in person or by phone.
Yes. Thank you.
That was a good summary.
You're hired.
I do it for a living.
Is there a rebuttal?
We want credit for that, too.
Okay.
Did we cover everything?
I think so.
We
I
don't
think
need to
we
do
have
anything
clear
else today.
enough direction and that we will resolve all of this at the next
No, at the special meeting.
Right.
At the special meeting.
You guys,
Because
no,
Bill
I
won't
meant
be
the
here on the
hearing.
8th.
The hearing that I will.
Yeah.
Because I'm not going to be here on the 8th.
Yeah, it's the one late one that you're going to be here.
Yes.
So,
So we entertain a motion to adjourn.
So, second.
All those in favor say aye.
Aye.
Need a roll?
no.
Thank you, everyone. Unfortunately, we'll have to see you again.
This meeting is adjourned at 2:53 p.m. 3 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 p.m.